Healthcare Law, Medio IGC 303, Unit 3. I'm Dr. Isabel Souza, your presenter for today. What is law? Let's talk about this. These are written rules established by society. Everyone is obligated to follow the law, and yet the law is continually updated. It changes depending on the cultural norms of the day. The origin of law can be legislative, judicial, and executive. Types of law, you have statutory law, common law, administrative law, civil, and criminal law. So there's quite a few different types of law. Let's go to the next slide, and we're going to discuss a little bit of this. So types of law, statutory legislative law. These are established by the legislative branch. And these laws are known as statutes. So the House and the Senate draw up the bills, and when they get voted on, they become statutes. Common and case law. These are established by the judicial branch, and they establish precedent. And we'll explain this a little more later. Administrative law is established by government agencies, such as the EPA, the DHA, and the FDA, commonly known as the Food and Drug Administration. So administrative law, we've seen some of the rules related to interpreting actually be from the Department of Health and Human Services, for example. Civil law involves relationships between people, whereas criminal law involves relationships between people and government. Now let's look at the next slide, and let's look at how this affects healthcare and standards of care. So healthcare professionals' performance is required to be consistent with the expectations of the profession, right? Remember, we went through all the different caretakers and all the different providers, and pretty much most of them, all of them, but the interpreter really were required to be certified in order to practice. And actually that is what we're looking for, that eventually medical interpreters will be required to be certified to even practice. Medical malpractice and negligence. So professional misconduct, illegal or immoral conduct, or unreasonable lack of skill. And medical malpractice and negligence is something that providers have to think about, and they have to pay big sums of money in order to have appropriate coverage to prevent any issue based on their mistakes. So failing to perform what is a reasonable, prudent interpreter would, or performing something a reasonable, prudent interpreter would not. So even thinking of our, case, if we interpret something inaccurately and it causes, an injury to a patient or even death, it can come to haunt us. So, malpractice and negligence, and sometimes interpreters, what we have is errors and omissions insurance, meaning that these are errors that were not intended to harm. Many professions have errors and omissions. Now, think about how important it is for us to interpret correctly, because there have been cases around the world where miscommunication and misinterpretation caused an injury. So you already heard about the Willie Ramirez case. I mentioned that in another unit, but there are so many other cases. One of the cases in which a hospital was sued entailed not translating the directions on how to use a medication. And the family read the medication once a day. ONCE sounds very much like once in Spanish, which means 11. And the parents actually overdosed this baby because of not understanding the usage. So because of that case and a few others related to prescription, now, prescriptions have to have the directions in more languages. So standards of care always improved because of the errors of some. And how do we prevent those errors is by improving the standard of care. So let's move on to the next slide. And proving negligence. So in order to prove negligence, the following must be demonstrated: that the interpreter obligated to perform services for the patient, that the interpreter failed to provide services for the patient, or that the interpreter's failure caused the patient's injury, or that the patient suffered injury. So those would have to be demonstrated. And that's why nowadays there's so much documentation on, was there any language access given to the patient? Who provided the interpretation? Was the consent form interpreted? By whom? Was the text interpreted? Was it just a conversation? All those things are very important because when a case is being examined due to any kind of sentinel event, any injury to the patient, that's how they go about seeing if the patient's rights were upheld, and the patient's right to access the service and also the patient's right to communicate are, uncontestable patient rights. So let's move on to the next slide. And let's talk about contract law. So contract is a legal document between two parties. Professional interpreters always sign contracts, are given contracts, and need to become familiar with them. An offer and an acceptance must be established. The interpreter offers a service, the organization, patient accepts that service. And the interpreter is free to choose clients and free to choose or decline assignments. As I've stated before, most interpreters are independent contractors and are dealing with different contracts with different facilities or different employers. And if it's an employment, even a regular employment, the interpreter will have to sign a contract and be bound by that contract. If a contract is terminated, it must be done appropriately. There's usually a termination clause in every contract, or the interpreter could be liable for abandonment. So the interpreter has to keep that in mind. And always be very transparent about rates, about conditions of work, about hourly minimums and no-shows, transportation, anything that the interpreter may ever wish to charge better be discussed beforehand and agreed on beforehand. A lot of problems can happen if the communication is haphazard. And in order to avoid miscommunication with all your clients, you have to have everything in writing, and you have to have everything clearly stated and not be ambiguous. Because if it is ambiguous, one party may interpret it one way and another the other way. So let's move on to litigation. The individual bringing the suit is the plaintiff. The party being accused is the defendant. Once the litigation has begun, the employee should not give any information without a consulting practice attorney or a risk management department getting involved. So, if for any reason a case you have interpreted for becomes a legal case, always consult with your client, your employer, your supervisor, the appropriate party, and act according to the, to whom you have provided the services to. Arbitration is an alternative to a trial or a settlement of a case, and mediation is a type of arbitration. So thank you so much for listening. We're going to end the presentation here.